10 seconds before we know 100% if we're live or not. But it's a pleasure to have you all here, and I look forward to our discussion. Hello, all those who are joining us. My name is Robert Baines. I'm the President and CEO of the NATO Association of Canada, a charitable organization devoted to the value of security and the importance of NATO. Most Canadians don't ever think about this, their security, but it's our job to make sure that they do consider it. It's essential that they do. Everything that we have, our cultural flourishing, our expectation of peace and security is based on many organizations and a combined rules-based international order that was developed after the Second World War to make sure that never happens again, that we never descend into the destruction and death that occurred globally during that horrible conflict. So to help make sure that never happens, NATO was created. It's a very simple, great tool that Canada was one of the founding nations in, and it says a very simple thing, that an attack upon one is an attack upon all. That kind of collective defense means that we can have peace through strength. Those are some of the lessons that we learned from the Second World War in the 1930s specifically. Today, of course, Canada and the rest of the world have entered into a time of significant questioning and challenges that are coming at us globally. So NATO is more important than ever. It's dedicated, and Canada has it as one of its main foreign policy goals to make sure that Canada and the rest of the rules-based international order is robust and working for Canada. So today we're going to be talking about cyber security and international law. This is part of our Challenges to Cyber Resiliency series. This is sponsored by NATO Public Diplomacy Division. We thank them tremendously for that. I would also like to thank two of our organizers, Alexia Mini and Nicole Doherty, for helping to put this event on. It's really stunning to be able to work with such a great team. So thanks very much. I should also encourage all of you, before we get into the discussion, to remember that this is an ongoing conversation. These kinds of ideas we have to play with and entertain and discuss again and again in many different aspects. So please do consider being part of our community, joining us on Facebook, LinkedIn, Twitter, YouTube, and of course, please do subscribe to us here. We'll get on to more conversations that you can take part in. But right now, I'm pleased to introduce our moderator for this discussion on cybersecurity and international law, Rafał Rosinski. He's the founder and principal of the SecDev Group and CEO of 0 Point Security, company specializing in digital risk and cybersecurity. His work on cybersecurity and digital issues spans more than 37 countries, including Iran, Russia, Israel, and Rwanda. In 2009, he led a team that discovered GhostNet, the first documented Chinese cyber espionage network that impacted over 109 organizations, including major governments in the Asia region. Rafał, it's wonderful to have you here to take us through this discussion. Please introduce the rest of our panel and get the discussion going. Thanks so much.
Thank you very much, Robert, and good morning to everyone, and welcome to this morning's panel on international law and cyberspace, part of the NATO Association of Canada series on cyber resilience. My name is Rafał Rosinski, and this morning I'll be your moderator for a fascinating panel that examines the importance of international law to the cyber domain and our current status of cyber insecurity. Governing cyberspace at a planetary level represents perhaps the most intractable problem facing Canada and the world as we enter into the digital era. In less than a blink of the historical eye, more than 2/3 of humanity is now connected to the global internet. By some accounts, approximately 25% of global GDP will be dependent entirely on the internet by 2025. The daily production and consumption of data is now in the zettabytes, and the use of data across borders and globally in the forms of value creation through artificial intelligence, growing autonomy, and its application to national defense, industry, and everyday life is only increasing. In fact, in the last year and a half, the COVID-19 pandemic has forced an acceleration of digital transformation. We have become dependent on devices and networks for a myriad of activities that only a few years prior would have been unthinkable to move from the security of bricks and mortars institutions and into the virtual life. And this has been accompanied by a tsunami of cybercrime, as cities, hospitals have been subject to ransomware and other forms of cyber malfeasance. And for the 50% of us that now are tethered to our digital devices on a 24/7 basis for daily life, this represents more than just a trivial risk. And yet, the means by which this domain is governed and the rules by which it operates, the basic interoperability at the legal level, at least internationally, is largely absent. Compared against the historical canvas, this is rather perplexing. In the last time we had a major technological advance with the start of the space age in 1957, a mere year later, we had a UN agency for outer space affairs established in order to provide a means to create a legal context for the exploration of states that was equitable and ruled by law for all member states. 10 years later, the Outer Space Treaty was signed, providing a framework for nations to cooperate and resolve their differences in this domain. But even prior to that, only 44 years separated the first manned space flight flight by the Wright brothers and the establishment of an international organization to set rules and governance for commercial air travel. And yet, by contrast, this year, the internet is just over 50 years old. And despite its game-changing implications at the human level, affecting all aspects of life, from individual to social, economic, and political, we have yet to establish an agreed upon governance mechanism or even rules of the road for some of the more critical aspects that this cyber domain touches, especially in areas of peace and security. So how did we get to where we are today? What frameworks or rules exist in international law that help us address some of the gross insecurities emerging from the cyber domain, ranging from data theft, ransomware, espionage, and cyber war? How do we address the current insecurities in the absence of a comprehensive regime of international law? And what are some of the future risks and opportunities for countries like Canada that we need to take in order to address these insecurities, especially in light of emerging technologies built on top of the internet, such as artificial intelligence, or the growing impact of large-scale technology platforms that harvest and reflect our behavior online, like Facebook, Twitter, TikTok, and others? And finally, what are some of the roles that institutions like NATO can play in helping to address the legal gaps and at least providing a framework of solidarity and action to deal with the global challenge of cyber insecurity? Well, to help us unravel this complex topic, we're joined today by two leading Canadian experts. Dr. Leah West is an assistant professor of international affairs at Norman Paterson School of International Affairs at Carleton University in the field of national security law. Leah had previously served as a counsel with the Department of Justice in the National Security Litigation and Advisory Group, where she appeared before the federal court in designated proceedings and the Security Intelligence Review Committee. Before being called to the Ontario Bar in 2016, Leah clerked for the Honorable Justice Mosley of the Federal Court of Canada, and prior to attending law school, Leah served as a Canadian Armed Forces in the Canadian Armed Forces for 10 years as an armored officer, where she deployed to Afghanistan in 2010. And thank you very much for your service, Leah. Kevvie Fowler is the partner and the Global and Canada Incident Response Leader at Deloitte, with over 22 years of experience helping organizations prevent and prepare for and recover from some of the industry's most high-profile cyber incidents. Prior to his time as Deloitte, Kevvie led the managed security practice at TELUS and was a founder of Ring Zero. Kevvie has served as an expert witness in data breach cases and is the author of several data breach and crisis managed books. Leah, Kevvie, welcome. Let's first turn to the current status of international law. And Leah, you've been a scholar and a practitioner of national security law for quite some time, specifically in terms of how it impacts on cyberspace. Perhaps to start us off, you can lead us through some of the current state of international law and how it governs issues such as interstate conflict, as well as other malicious activity in cyberspace, ranging from data theft, ransomware, and espionage. Leah, over to you.
Okay, so first I'm going to apologize. I'm in my office at Carleton and there's construction noise. So if you hear it, I apologize for that. But I'll just start by backing up for the audience members who aren't international lawyers to remember that the primary sources of international law are treaties between states and customary international law that's derived from the practice of states over time. And I'll say that there is no treaties that currently specific state conduct in cyberspace. The only international treaty aimed directly at regulating online activity that currently exists is the Convention on Cybercrime, which actually just calls on states to implement domestic criminal offenses and enhance investigative tools for local law enforcement. So we don't have a Geneva Conventions or a space treaty when it comes to cyberspace. There are, however, existing treaties, specifically and most significantly the UN Charter and the 4 Geneva Conventions and customary international law that are widely accepted as generally applicable to online state conduct. And in the past, there's been major efforts by both the academic and international community to identify how existing rules that were meant to apply in different warfighting domains, for example, apply in the cyber domain. The most prominent academic study was undertaken by an international group of experts producing the Talon Manual for the first time in 2013. That was just about cyber warfare. And then they updated that in 2017 to be applicable to what we call cyber operations. But importantly, the Talon Manual, for all that we rely on it, is not law. It is a scholarly work that outlines where, at the time of publication, scholars agreed or disagreed. And that's important. It also talks about disagreement on the state of the law. Rafael, you referenced the UN processes. So we've got the UN group of governmental experts on developments in the field of information and telecommunications in the context of international security, or the GGE. Now, the GGE did reach consensus on a number of general principles, producing 3 substantive reports since 2010. Of particular note, there was agreements that states should not knowingly allow their territory to be used for internationally wrongful acts using information and communication technology, or what the UN usually abbreviates to ICT, and that states should not conduct or knowingly support ICT activity contrary to its obligations under international law. However, the GGE process stalled in 2017 when it failed to reach a consensus on how international law applies, specifically to the use of ICT. Very briefly, the divide exists. I'm generalizing here, between the US and its allies who want to see clear guidelines on the use of force and the conduct of hostilities in cyberspace, while Russia and its allies, including China, have been pushing for the creation of a code of conduct, which really emphasizes the protection of states' cyber sovereignty. So in 2019, a parallel process that was first introduced in the UN by Russia was established. Canada originally pushed back on that process, but did join it. And it was a broader consultation process. But it does signal this divide in the global community about how to approach law in cyberspace. Now, the OWEG, so the Open-Ended Working Group, did publish a consensus report this year. It's an 11 pages after 2 years of work, covers the following: existing and potential threats, rules, norms, and principles of responsible state behavior, international law, confidence building measures, capacity building, institutional dialogue, in that order. In the limited half page that actually focused on international law, only one single line of agreement on the law can be found. And all it says is international law, and in particular, the Charter of the United Nations, is applicable to the ICT. So that process around international law, having been a part of it, was definitely the most contentious. There was even contention about whether it should come before norms or after norms in the process. And that's all the international community could ultimately agree on. That said, the GGE efforts and the Talon manuals have significantly advanced our understanding of international law, its application in cyberspace, and Talon Manual 3.0, a group to study evolving customary law, is deemed established right now. And individual states, again, the subjects in international law, are starting to step up to the plate and enunciate their position on international law. And of course, scholars continue to fill this void, but there are still many, many areas of absolute disagreement when it comes to, especially, which we'll talk about, gray zone or below threshold operations. But I'll leave it there.
Great, Leah. Well, thank you very much for that overview. I think that's very helpful, especially for those who perhaps aren't well versed to the difference between conventions and what exists as body of law. But maybe taking off your sort of pedagogical hat here for a second, and asking you to speculate, why is it after 50 years that we haven't been able to come up with either, some mechanism through existing UN institutions, such as we did with the Outer Space Treaty and the UN Outer Space Treaty Organization, or at least some kind of broader convention? Well, why do we have this continuing rifts? You mentioned the fact that there's a difference between positions taken by the like-minded, as they're called, which is basically the European countries plus the US and others, and the bloc led by Russia and China. But what is the essential difference here? Why has it been so difficult to come to a consensus?
I think one reason is because every country has a significant stake. Unlike in past instances, you only really needed to get 2 countries to the table to create a space treaty back in the day. Same with nuclear convention, armed conventions. And the issues of cyber and international law are all encompassing. It's not just one unique element of international law that we need to be thinking about, right? We're not talking about a convention on landmines here. We are talking about a full spectrum of operations that is continuously and constantly evolving. And states aren't willing to give up any territory yet. And I think that is really driving this, is that no one wants to really give up any avenues for operation at this point, because also the world is so incredibly unstable. So that, putting it all together, it encompasses so much. Every state has a stake in what happens here. And the technology continues to evolve so rapidly that I just don't see the treaty process really being the way forward. I really do see this as something that is going to evolve through the adaptation of customary international law over time.
But we've had successful cases of this past. Maritime law also had multiple stakeholders in terms of coming up with at least a modicum of agreement around what was the minimum threshold. And in the cyberspace, we don't. And I think maybe here, it's useful to raise the fact that one of the principal differences that's been raised through the UN process, going back to the 1990s, has been that the position of the like-minded has been that the UN shouldn't be the mechanism through which the governance of cyberspace is going to be resolved. The position of the US in particular around multi-stakeholderism runs very contrary to the position put forward, not just by Russia and China, but multiple countries that say, look, national law should actually prevail in terms of how cyberspace is governed on a territorial basis. That there is a degree of sovereignty that should be exercised that prevents predominantly Western technology platforms for being able to exploit what is otherwise seen as national space. And I think as we've moved through time and seen how this domain can be leveraged by states to create, to some extent, meddling with internal processes, such as with elections in 2016 and others, there is a recognition that sovereignty does matter and that national law should prevail in the way that cyberspace is parsing. So I guess I'm wondering, from your perspective, is there a pathway towards a treaty because of the growing recognition that not only does cyberspace affect us all, but that our ability to govern it ultimately has to be subject to some body of law that's universal, whether that's national or international?
I'll go back to your example, and I'll say that the codification of maritime law, it is not something that happened overnight based on a bunch of people sitting around a table. It was a codification of existing customary law that had developed over hundreds of years through state practice. And that's how states could agree and come to the table, because it was already practices that was well respected and put in place. And we still have states like the United States who have not signed on to UNCLOS. So unfortunately, I do think the evolution of customary law is still where we're going to see the law really develop here.
Great, thanks. Well, Kevvie, you've been very, very patient here. And I think, you don't come at this as a legal scholar, but you do come at it as someone who's had to deal with the absence of law, especially in cases of data breach or cyber malfeasance, where really the chain of evidence leads you well outside of what it would be otherwise considered Canadian sovereignty. When you're dealing, for example, with servers that have to have data pulled off of them from Singapore or suspects that could be located in countries like Nigeria, the framework that currently exists under the Budapest Convention very quickly starts leading to its limits. and you're forced through multilateral legal assistance treaties to sometimes go into very long processes to get any kind of recourse under the law. So I'm wondering if you can take us through, how are commercial actors, which frankly are probably those most impacted by malicious cyber activity, adapting to an environment where they don't have recourse to international law in order to be able to resolve what at times have been major liabilities and major losses?
Thanks, Raphael. I'm going to answer your question from a corporate standpoint, but using two different lenses. The first one's proactively, before an incident, and some of the pitfalls you mentioned. And the second one is reactively, after an incident has occurred. Looking proactively, I see this day in and day out, organizations struggle on defining what a good level of cybersecurity actually is. The key factors that corporations typically look at would be, what are the regulatory requirements based on the nature of their business? What are the legislative requirements as well for how they need to protect information? What type of contracts have they signed? What are the commercial requirements? And also, what are the public expectations? And that's driven by common law, which is national, to your point earlier. So there's a lot of requirements. If they sit back, look at their business, look at the type of information they have to protect, and then identify all the requirements. These requirements, as both yourself and Leah mentioned, differ when you look at different states and different regions. Currently, cyber law is much stronger across some regions, EMEA, North America, in contrast to Latin America. Determining what is good enough is a difficult task, and quite often organizations can actually test if what they did is correct until after a security incident, when they face pressure from regulators or partners, litigation that's driven as a result of the incident. The way we see organizations managing this is, I think you hit the nail on the head before, it's really engaging global law firms who have the expertise across jurisdictions. They're more intimate with the local laws from a common law standpoint, from a legislative standpoint, and really pulling it all together to identify what good enough looks like. And that may actually differ depending on the region across the same organization. Is the approach that we see most organizations take to be successful. We are seeing some pockets of relief, though, regarding some emerging law. If you look at what's happening in Ohio in the US with the Ohio Data Protection Act and the safe harbor provisions, if your organization can demonstrate compliance with a set body of security controls, a lot of incident-related litigation can actually be knocked down at the state level. If that can extend to other states within the US and other countries, I think it will help make things a lot easier for organizations as they focus on defensibility and really determining what good enough looks like. So that's on the proactive side. On the reactive side, when an incident actually hits, trying to determine what steps they need to take to respond and recover is equally as daunting. Because the legislative requirements, common law, commercial requirements, that again varies depending on region. And typically there's a global legal team that comes together to determine who they have to notify, how they need to notify. Even the privacy commissioner and privacy requirements will differ. And it is a pretty daunting exercise to go through and identify that. From an investigative standpoint, a lot of times you're tracking threat actors or threat groups and the trail leads to another country. It's okay when there are strong relationships between, for instance, Canadian law enforcement and some of the foreign law enforcement agencies. If the trail leads to a country where they don't have strong relations, the trail can go cold really quickly and very difficult to warm back up.
So what you pointed out to is actually kind of interesting in the sense that, on one hand, corporations are now starting to come under regulatory pressure to be able to deal with the consequences of malicious cyber behavior. Data protection laws, for example, are now starting to, especially through in the United States, put very heavy fines on the loss of data, for example, through known breaches. And yet at the same time, the ability of corporations to be able to count on governments to act in their interest when responding to either proactively or post-event just doesn't exist. So where does that lead us to? And I guess maybe, Leah, I'm going to just turn to you here, because one of the points that you pointed out is that we don't really have a body of international law that is fully satisfactory. And certainly it's not fully satisfactory, for the bulk of what currently makes up the cyber domain, which is private interest. So you kind of mentioned before that there are alternatives, or there potentially are alternatives, and you mentioned that corporations are starting to take steps. I think that the one that comes to mind is Microsoft and their digital Geneva Convention proposal as one mechanism for trying to come up with a set of norms that then can be turned into some form of enforceable mechanism. But private international law is potentially another area, and I realize that this is not the area that you've spent a lot of your time from a legal point of view, but you surely you must have an opinion on. Is this a viable path forward? First of all, what do you think about these kinds of efforts? Is this really, in the absence of government action, going to be the place where we're going to see the most legal innovation over the next decade?
Well, private international law is really just domestic law, but you decide which forum you're going to argue in advance usually. So you're still having to rely on states, and so I don't focus on the commercial aspect of things. I focus more on the cybercrime prosecution side of things, which, I mean, aside from corporations ultimately not understanding what their rights are, what their obligations are, and how they need to respond to their shareholders, for example, there's also the how do we actually investigate, prosecute, and ultimately deter this kind of activity from happening in the first place. And so I mentioned the Cybercrime Convention, which put obligations on states to create certain laws and give new powers to law enforcement. But I'll just say, like, those new powers in Canada were extremely controversial. And essentially, the passage of the Lawful Access Bill in Canada was one of the things that almost ousted a public safety minister. So it's very contentious in this country. The powers that states need to actually investigate and prosecute cybercrime is highly intrusive to an extent, but they also need to have quick capacity to operate cross borders with other law enforcement agencies and international bodies who hold the evidence they need that are located in different jurisdictions. And so this is where we see that MLAT process that you mentioned that is super slow and cumbersome, not working, being reconceived, for example, by the United States with the Cloud Act, right? So I think that's the way forward, at least from a prosecution side. I really can't speak to the corporate side, but from a prosecution side, I think like-minded states who have similar, for example, privacy law and respect for the rights of people to communicate online, to create bilateral or multilateral agreements to allow law enforcement investigators in one state to reach out, not through the government in another state, who then reaches out to the other, has to get a court order, then to go to the corporation and like that long process, but to simply serve a warrant issued in Canada against, for example, Facebook in California. And I think that we've seen that happen with the US and the UK. I really think those types of agreements where states will recognize each other's production orders, for example, will really help in terms of bringing to justice, or at least investigating these crimes that are just, becoming more and more rampant.
Yeah, and I think you're right. I mean, as long as you're still dealing with countries that at least share a certain degree of if you like, legal interoperability, those production orders can be quite good. But what happens when you're dealing with countries where that just isn't the case? International data theft and IP theft, as we all know, has become rampant, and certainly fingers have been pointed at a certain number of countries that are most responsible for it, either from a malfeasance point of view or just from a theft point of view. China and North Korea come to mind. The Trump administration, in particular, over the past 4 years when it was in power, started making more use of trade sanctions and naming and shaming as a means of effectively doing what law enforcement otherwise couldn't do or practically couldn't do. I guess, Kevvie, turning to you, because invariably trade sanctions are a double-edged sword. From your perspective of kind of having looked at its overall impact, is this a really effective way of dealing with cyber malfeasance and for example, IP theft, or is it ultimately counterproductive because it invites retribution?
That's a great question. I think it would fall on the side of being counterproductive, and I don't think it holds enough teeth in terms of the trade sanctions that have been that have been laid with some of the material cyber attacks that we've seen from state to state. I think the reason for that is just uncertainty regarding attack attribution. And international law, when you look at it today, it states that states should warn other states before attacking, and any state is responsible for the actions of non-state actors under their control. So after any major cyber attack, there's an investigation that happens. And the common language, to your point with naming and shaming, is intelligence suggests the attack came from fill in the blank here. There's no details regarding how they actually came to that determination. And when you look at attack attribution from a technical level, it is very, very difficult to do. You look at how the threat actors gained access, how they connected to the network, how they moved around, the type of information they were looking at, the type of language artifacts on systems. But in most cases, there are indicators that point to multiple states or multiple threat groups. And it's very difficult to put your finger on just one. So we've seen reports where states have actually applied additional factors such as politics and geopolitical context and history. And they put all this together and then they make a determination of who they think is behind the attack. There's no standards today regarding minimum level of investigation for attribution, no governance into how this is done. And I think until that can be addressed, I don't think we're going to see swift responses to state level attacks from an attribution standpoint.
So I think this nicely comes back to your wheelhouse, Celia, because if we were to sort of point fingers and say, who are the actors that are most likely to be destabilizing from either a destructive cyber malicious point of view or simply outside of the spectrum of being able to use production orders to do it? We're thinking of China, we're thinking of Iran, we're thinking of North Korea. So in this case, absence of really a body of international law, except for the law of armed conflict, which of course has the sub and above threshold, are things like naming and shaming, which the US has used fairly extensively, including effectively serving national warrants against intelligence officers from the People's Republic of China. Or, for example, extensive trade sanctions, really the only options we have. And from your perspective, sort of the national security perspective, is this a warranted action? Is this something that actually can have the right shaping effect?
So I think I'm going to go back and disagree with the underlying premise of your question. And that is that international law isn't effective and doesn't work. And I think that that's not true. I think it can, but it needs to be developed through state practice, right? So when there is an attribution, for example, states need to not only attribute, but they need to specify what violations of international obligations resulted from that attack. And then if states respond, right, as a countermeasure, they need to follow the law and explain why they're responding in accordance with the principles of state responsibility, for example, right? And that's how you get international law working in this space. And states are starting to do that to a limited extent. States are more frequently coming forward and saying how they interpret international law, both in terms of what they themselves are, the kind of activities they're engaged in, and how they see, for example, certain attacks that have already previously occurred, how they violate different elements of international law. That's how we get international law working as being an actual tool that can be used here. But again, it has to come from state practice and opinio juris. And as so long as states are afraid to actually enunciate their positions on international law and how different activities are violating that, because maybe they do the same thing, that's where we're going to see the continued breakdown of international law.
Okay, but maybe to push back on you here, I mean, even under the Trump administration, where we definitely did see cyber responses, these were never enunciated, under laws of armed conflict. These were used, different mechanisms used. As I said, for example, trade sanctions were used fairly extensively as a means of being able to respond against what was otherwise seen as a violation of sovereignty and data theft. So I guess the question here is, do we see two paths? On one hand, an evolution of international law in the way that you've stated, where it's based upon some practice that is codified, but on the other hand of the spectrum, also the use of of other mechanisms such as sanctions in order to be able to provide enforcement?
Well, I guess it depends, right? If sanctions violate the WTO, they are a countermeasure under international law to a breach of international law. And that's how people are conceiving them, but nobody's saying that, right? And nobody's actually enunciating, this is a countermeasure. We've attributed this act to China, right? They violated our sovereignty. In response, we are violating our WTO obligations to China by imposing these sanctions in response. So that needs to be added to what we're already seeing. And so, yes, it is to track. And like deterrence, again, is about, if you do this to us, we have a legal right under international law to do that to you, right? And that is the type of things that needs to start to be enunciated. And then there needs to be follow through, right? Deterrence doesn't work if nobody ever follows through. And we are also seeing problems there. So it can't just be about naming and shaming. It needs to be about enunciating the law when you're naming and shaming, and then actually following through, and then attributing your follow-through actions also to the law. And that's how we see the law develop here, just like any other area of law.
Great. Well, thank you. And I think that kind of nicely segues us into sort of the third question that I tried to put at the beginning of our panel. And that is, look, cyberspace is evolving. And really, a lot of the work that the GGE has done over the last 10, 15 years was really focused, as you said, Leah, on ICTs. In other words, focusing on the transport mechanism, which is now the ecosystem for data that we're now processing on a planetary scale. And I think we've already seen how harvesting of behavioral data from platforms such as Facebook, Twitter, and others can be manipulated in order to undermine trust, sow discontent, and put at risk fundamental institutions such as democracy. And I guess the way to capture this is as gray zone operations that happen on the internet rather than in the internet. The coming age of autonomy and international and artificial intelligence is going to open up a whole new spectrum of harms. And absent of government norms and codification, this is going to lead to further instability. In recent years, as you know, the UN has convened another GGE that looks specifically at autonomy and artificial intelligence. And the fact that we haven't yet been able to find norms around the previous set of problems as a transport mechanism obviously doesn't lead to a lot of optimism that we're going to be able to resolve these larger sort of gray and emerging area things. So Kevvie, I'm going to turn to you maybe and ask you to put on a futurologist hat, which hopefully isn't cone-shaped like mine, and ask you, what do you see as the sort of greatest evolving set of challenges in the cyber domain that are going to, make even more complex this mixture of absence of international or functional international law and workarounds that we see right now?
Well, you indicated a few aspects of what's known as cognitive warfare regarding leveraging social media, messaging platforms, news feeds, search engine results to really shape and influence the beliefs and behaviors of individuals or groups to achieve a certain objective. When you look at this, you can, to your point, you can take information or data out of these platforms and analyze them, or you can manipulate the actual platforms themselves. And you can alter the perception of reality for certain individuals, and that could drive domestic attacks against states, corporations, etc. As futuristic as that sounds, it's, as you know, it's very real. We've seen reports of this impacting elections and several other key events. To your point, as sophisticated, as interesting as this all is, from my view, it is literally still throwing darts in the dark. Actors deliver content to specific individuals or groups without knowing if it's being successfully received or if it's being processed by the subject. The missing link, I think, will be filled by emerging technology. And this technology is directly interfacing with the brain, and that's on the horizon. When you look at elevating cognitive warfare to an all new level of risk, it comes down to, as crazy as it sounds, automotive makers. And if you look at the B2V protocols they're coming out with, brain to vehicle, now people are being able to be connected to their vehicles, and you can drive and interact with your car using your brain waves. You look at leading tech companies who are now showcasing brain chips that allow people to better interface with their technology. And it sounds great from the usability standpoint, But exploiting this technology can allow you to understand when cognitive warfare campaigns have actually reached their target and if they were successfully processed. And that's the missing link. That's turning on the light while you're playing darts. And it's possible that even the level of weaponization of specific targets can be identified based on tapping into some of this technology that interfaces with the brain. So we're entering new waters here from a tech perspective when you look forward in the future of technology. And to answer your question, the next 10 years, I think will be unlike the prior 50 years. If you look at your opening regarding the internet and technology and how we've been able to accelerate just development as a society. I really think getting in front of cognitive warfare and emerging technology specifically is going to be one of the most important challenges faced by the industry in the next couple of years. Literally, it's going to solve the last piece of the puzzle that's missing and allow states and groups to launch very sophisticated attacks that are very difficult to detect, that can be very damaging to organizations as well as states.
Great, thanks, Kevvie. And just before I turn to you, Leah, with basically the same question, I just want to remind for all of you who are listening to this webinar online that we will be taking questions from the audience. And you should see on your screen an ability to type in a question. Please do so. Our moderators who are furiously working in the background will reformulate the questions and we'll get them out to the participants to this panel so we can use the last 10 minutes as a means of addressing some of what you have. So Leah, you've heard what Kevvie had to say. What's your thought on the future?
So I'm just going to step back and classify it according to the law right now. So this type of activity, totally permissible inside armed conflict, right? Psychological operations is something that we've been doing in the land forces since wars began, right? To manipulate your enemy and those under your occupation to advance your military interests is not anything new. We're just doing it in a highly sophisticated way. But now we're also doing it outside the context of war and targeting specifically civilian populations in order to have an impact on a foreign state's control over its sovereign responsibilities. And that's what's really different here. We've always had foreign influence, right? This is a classic thing. It's been in the CSIS Act since the CSIS Act began, foreign influence. But and covert foreign influence, always understood that that was a thing that was happening, but we always understood that that would be somewhat targeted. And typically, you see it at diaspora communities or politicians. But now we're seeing an influence campaign outside the context of war, outside your classic espionage, really as a way of simply manipulating the populations in foreign states. And you asked about the biggest concern for the future, and for me, it's not just about bots pumping fake information. It's about protecting the integrity of data so people have confidence in their institutions and democratic processes. So I'm actually doing a 2-year government-funded grant on this, is what is the law around this? Because right now, when you're talking outside of armed conflict, operations that fall below the threshold of a use of force, right? So you're not talking about taking down cyber networks. You're simply about altering or deleting data. For example, the law is absolutely unclear here. This isn't like what I was talking about before, where it's quite clear, we understand what the rules are and people just need to be enunciating it. Here, the law is really truly developing because it is so unique. Sovereignty is based on this principle that you have control about who's in your state. You have control about who in your state is doing what, and you can keep unwanted actors out or remove them. You cannot do that in cyberspace. And that's why the law becomes so complicated around this notion of sovereignty in cyberspace. And the worries I have are about operations where they start changing the blood type for soldiers in a foreign adversary country, or they go in and tweak only a few votes, but not all of them, just enough to make everyone lose confidence in the voting system. Or you're changing code words for military operations or nuclear codes, or everyone's tax numbers or whatever, CRA numbers start to be confused, right? And we start to lose trust in our democratic institutions. And that isn't hard, but it's not what we're used to thinking about in terms of cyber attacks. It's very simple, easy manipulation of data that causes people to lose confidence. And that's my biggest fear. And this is an area that is absolutely unsettled and why I'm going to be studying it for the next 2 years.
So this is really interesting because it actually takes us full circle back to this issue of norms. As you probably are aware, back in the 1990s and certainly throughout the 2000s, one of the positions that the Russian government took vis-a-vis the GGE was for informational sovereignty. And then the basis for that, if you take away Putinism and everything else, really came down to the fact that during the 1990s, Russian elections were manipulated. You had the presence of IRI, NED, any number of groups that worked with Russian political parties that were there in order to ensure, for example, that Yeltsin won in 1996. This is a fairly open thing. And to some extent, Russia's position on cyberspace, was formed on the basis of that lived history to say, look, why should we be allowing others to effectively work for whatever reason, whether it's democratization, making the world better within our sovereign space? For a long time, the like-minded disagreed with that, or at least disagreed with Russia's position because they saw that as a pathway, not to national sovereignty, but to sort of information totalitarianism. Now that we've lived through 2016, suddenly this question comes back to us. So I guess, if I was to ask you to speculate, and nothing's on the record here, Leah, so we're not going to write this down, should we be now moving our position closer to the one that was advocated by Russia and China 10 years ago, where we do need to have sovereign national law that provides a regulatory framework on how international platforms or technology platforms can impact on behavior and on institutions at the national level?
So is your question about whether or not we should have domestic law that governs this, or whether or not the law should evolve to have
whether domestic law should have paramount in terms of the governance over technology platforms? In other words, back to the sort of informational sovereignty aspects, which were the Russian position 10 years ago.
I don't know that solves the problem, because those good actors will then be regulated and bad actors will still circumvent the law. So I don't know that creating an informational sovereignty, like having siloed internets, for example, based on state kind of sovereign firewalls, is the way to resolve that problem, because bad actors who are seeking to do what they will, especially state actors, will find a way around them. And domestic law, in the state, when you're in another state engaging in a cyber operation, domestic law in that foreign state of what they can do to you as a domestic, as like a single person, is not a deterrent. Not yet anyway. So I don't think domestic law is the solution. One thing I will go back to, because we didn't get a chance to talk about it, is states are increasingly allowing and empowering their state actors to take action in the gray zone. Canadian state actors have legal authority to engage in below threshold operations. Both CSC has active cyber operations, which could actually cross the threshold, and CSIS can engage in threat disruption measures, which can be done online. So we're actually giving our state agents authority to do something. Under Canadian legislation, they're supposed to be compliant with international law if you're CSE, for example, but nobody knows what that law is. So we now have domestic actors in Canada that are supposed to be bound to international law. And Canada has never enunciated its understanding of international law's application in cyberspace, which is incredibly dangerous. And I think going back to the NATO position is, if Canada is not enunciating its position on international law such that even its own actors can understand what its rules of engagement are, essentially, how can we then be a contributor to an organization like NATO that is trying to shape this space? So I'll just leave it there.
So this is a really excellent way to maybe ask you a final question, or both of you a final question, before we move to questions from the audience. NATO has, for the last more than 7 years, been the framework for collective security for Canada and engagement transatlantic. And yet, if we look at where Canada's trade engagements now are, it doesn't necessarily align with those countries. Our interests now are more diversified, focused on Asia. Given the fact that legal interoperability for the global digital ecosystem really depends and really impacts most on Canada's trade and Canada's economic relationships, what role does NATO have really in developing rules and norms? Shouldn't we be developing those rules and norms jointly with the countries with which we have the strongest economic relationship rather than a legacy security relationship? And us, maybe Kevvie, if you can answer that first, given the fact that you work in the private sector and that essentially the commercial aspects are maybe more paramount, and then over to you, Leah.
Sure. From a corporate standpoint, or putting the corporate lens on, and if you look at cyber law, there's a lot of pressure and stress that's being placed on laws, and there are indicators that it may splinter in the impact that the laws have, tending towards cyber physical systems. And this would be cyber assets that are connected to physical systems, whether it's hospital equipment, power grids, autonomous vehicles, etc. So any connectivity between cyber and physical systems, that can result in direct impact or casualties to human life. There's a different consequence associated with that. And there's a lot of pressure that's currently being placed on both the public as well as regulators are starting to look at this now. There are new laws that are being invoked. Look at the Corporate Executive Accountability Act from 3 years ago. They're trying to place personal liability with the heads of corporations for lapses in cyber that result in some of these attacks against cyber physical systems. If that gets traction and there is personal liability now for executives, there should be renewed focus on cybersecurity to avoid personal liability, jail sentences, etc. And I really see that splinter happening from a law standpoint, and that would trickle hopefully from an international standpoint. Because when you're dealing with ones and zeros, and whether it's SIN numbers or credit card numbers, that's one thing. When you're dealing with actual loss of human life, it's a very different situation, and one that can also help pass that threshold, to Leah's point, regarding when you would trigger an attack that actually would signify an act of war. So really helping to enforce those policies, I think, would definitely be critical, and doing so on an international level is where NATO would help with that.
Thanks, Kevvie. Leah, same question to you.
So I would think, in my personal opinion, NATO should remain focused on international humanitarian law and human rights law as it applies during an armed conflict, and state responsibilities that arise in an armed conflict situation. NATO doesn't govern the state's actions, its member states, outside of an armed conflict, right? The alliance is meant to respond and react once an armed conflict or an armed attack occurs, which triggers an armed conflict. So I think where NATO can help is by helping NATO just did a big attribution. I can't remember if it was Solar Winds or the pipeline. I think it was the pipeline attack, where NATO came out and actually attributed an attack. And so I think where NATO can really help is when an attack does cross a threshold that would trigger international humanitarian law, that it's very clear about why it has triggered that, why it's crossed that line, and to move forward to also talk about other examples of things that would trigger an armed attack. So it can help set thresholds right now. The other thing, I'm involved in a project with NATO, the CCDOE, where we're talking about how we need to adapt existing human rights law and international humanitarian law around privacy and data in armed conflict, because we know that the wars of the future are going to be heavily data reliant. And that's not something really contemplated by the laws of war. And we just have to look to Afghanistan and the biometric scanners and the biometric data now potentially in the hands of the Taliban to understand why modern warfare, the collection of data, the manipulation of data is something that we need to be thinking about. And that's where I would like, again, to see NATO take a stronger role rather than focusing on this commercial element of things.
Great, thank you. And as we've been going along, I've been trying to roll up some of the questions in the chat, but there's one that actually stands up. And again, I'll send it to you, Leah, because it's an interesting one. The questioner asks, is there a fear of trying to legislate when IT and cyber worlds are evolving so rapidly? In other words, is part of the problem here not just the fact that law takes time to develop, but that there's actually a hesitancy on the part of legislators or of leaders to do so in fear of getting it wrong?
Yes, short answer. As someone who wrote the new data aggregation and collection legislation for the Canadian government, I could say yes. And trying to write law on something like data collection that withstands evolving charter scrutiny as what data collection and use looks like and analysis looks like over time is evolving. What you end up with is pretty vague law. And you have to be careful, because if law is too vague, then it becomes unconstitutional. So you're trying to constantly thread this needle. And I'm going to focus on Canada here, is that we're really bad at updating our laws, especially in the national security and tech space. Also the privacy law space. These are all areas of law where we wait, 10, 15, 20 years before we modify the law. And that is a habit we must absolutely get out of. Updating our national security laws, updating our privacy laws, updating law about the collection, sharing, and use of even data on the private side. All of that needs to become routine and regularized so that we get out of this fear. And the idea of going through this process doesn't, put the fear of God in legislators, and we just do it routinely. That has to be the way forward.
Thanks. I'm going to come back to the point that both of you made about the relevance of the NATO alliance. I think it's an old maxim that says that generals are doomed to always plan for the last war. And while I'm very sympathetic, with what you said, Leah, about the fact that NATO really should be focusing on international humanitarian law and sort of the definition of what is a act of war, it's also been pretty clear from the statements of President Putin as well as President Xi that they feel that they are in a contest with the West, and that contest has multiple dimensions. Some of them are going to be military, but many of them are not going to be military. And I think the cyber domain is the one where we've had the greatest difficulty in being able to classify what constitutes an act for which there should be a response. If we were to strip away the politics of it and look at something like solar winds or the pipeline attacks or the ways that information has been manipulated to undermine political processes in both Europe and in North America, it's hard not to constitute that as an act, an aggressive act. And yet there isn't an enforceability, there isn't a response, or at least there hasn't been a response that had any sort of significant consequence. So I wonder again, is the part of the challenge that the Security Alliance simply is fearful to embrace cyber as something which requires the same degree of response as we would for kinetic operations, or is it the Alliance simply not the appropriate mechanism through which to respond? And I know that there's been a lot said between the Warsaw and the London summits on this topic, but just wanted to get your opinion on that. So maybe Leah first and then Kevvie second.
I don't think the Alliance is the appropriate mechanism for that. So again, I think we have a lot of tools in our toolboxes. We have trade, we have diplomacy, we have our own espionage, foreign intelligence capabilities, and then we also have defense. And I think we need to be using the full spectrum, because cyber operations track that full spectrum. So I think it's too much to say that we're going to really solve this problem by being at the pointiest end. I think we need to go across that spectrum and be resolving, picking the tool from the toolbox that's most appropriate in the different circumstances.
Kevvie?
On my side, it's more of a legal question, but I agree with the underlying point that you're making. When you look at corporate attacks, I do think we're going to have threat actors, threat groups who are launching attacks that have undesired consequences, which is impacting a large degree of human life, or corporations that has a cascading impact on a state. And I do think that in the future, that will trigger thresholds to actually cause retaliation. And I think NATO will have to look at both. I don't think we can separate the two looking forward for the next 5 or 10 years. I think it's really going to be intertwined in terms of what the response needs to be, looking at both corporate as well as state level attacks.
Great, thank you very much. And we're now at the top of the hour. I know that one of our panelists has a hard stop. So at this point, I'd like to thank both Leah as well as Kevvie for your participation. This has been a really fascinating discussion. For those of you that are viewing this on the internet, this will be available for both download as well as viewing afterwards. And on that, I'd like to thank very much the NATO Association of Canada and hand the chair back over to Robert Baines.
Thanks so much, Rafael. And seeing as you thanked both of our fine panelists, now allows me to thank you for doing such a great job of winding us through this discussion. And it's one, again, that will go on. And particularly the end bit there, we will be having a panel on NATO and cybersecurity specifically. So everyone, please do, as I mentioned earlier, stay engaged with us, Facebook, LinkedIn, Twitter, Instagram, and of course, do subscribe to us on YouTube. We're thankful for NATO PDD for sponsoring this, and of course to our panelists for joining us, and for Alexia Meany and Nicole Darty for helping us to organize this fine event. Thanks so much, everybody.